Welcome everyone, and thank you for joining us today on Level Up Law, where South Carolina Legal Services is leveling up your legal knowledge on the different areas of law that we handle. I'm Susan Ingalls, attorney with South Carolina Legal Services, and I'll be the host of the webinar today, along with our producer, Kenneth Elliott, from our IT department at South Carolina Legal Services. We are joined today from our office in Greenwood, South Carolina, by Attorney Lanier Sims and Regional Benefits Paralegal Mary Lou Seymour. This will be the first of a two-part series addressing issues that may arise with special needs children. Today, Mary Lou and Lanier will be talking about issues that arise during the ages of 0 to 18. So that should be really helpful to our listeners. And so we appreciate them being here to share that today. As you view the presentation today, please do remember that this is not legal advice, but just general information for the public. You should always consult with an attorney for any specific legal issues that you have. Now, we will provide information at the end of the presentation on how to apply for free legal assistance here at Legal Services and how to access our public information and resources. And as always, a recording of this webcast will be posted to our YouTube channel later this week. That's at SC Legal. And that will include the slides that Lanier and Mary Lou are using today. Now, even though you will be in listen-only mode today, please be sure to take advantage of this opportunity and put any questions that you have in the question box that you see on your screen. And as time allows, Lanier and Mary Lou will provide some general information to hopefully answer those questions. Again, thanks everyone so much for joining us, and Lanier and Mary Lou, take it away.
Sorry, after a year of this, I'm still forgetting to unmute myself sometimes. Thank you, Susie. So as she mentioned, I'm Lanier Sims. I'm an attorney in our Greenwood office here, and I handle education cases involving some of the issues we're going to talk about today. So I just want to start off with, reiterating, we're only going to be talking about educational programs and other benefits or programs available for kids from 0 to 18. Specifically, we're going to be talking about those programs that are available for preschool age children from birth to 5. Then Mary Lou will take some time to tell us all about Social Security, disability, and supplemental security income that these children may be eligible for. And then I'll wrap things up talking about special education and accommodations available for school-age children from 5 to 18. And then if we have any time at the end, we'll answer any questions y'all may have on these topics. And just before we get started, I want to mention we did get some questions on issues like custody, guardianship, power of attorney, housing accommodations, and other things that might be pertinent to kids with special needs, and we do plan to address those. That'll just be in a different webinar, and that's primarily just so that we have the opportunity today and the time today to get into everything that we want to tell you about with regards to education and the other programs for these kids from 0 to 18. So with that being said, one of the first things I always tell people in these education cases or dealing with the special education things is that parent participation in the process is crucial. These school districts and school officials and personnel, their job is, to follow the letter of the law and to provide services for the kids, but they can only provide the services the child needs if they have all of the information they need. And one of the best places for them to get that information is from the parents. And also, I tell people that their expectation is crucial because going into these processes, sometimes parents don't know what to expect. And so hopefully after today, they'll have a better idea of what they're going into, what they should expect from the school district, or from any of these things that we talk about here today. This is going to be important as we talk about all the education things today. You'll hear me say IDEA repeatedly and probably too many times throughout today's webinar. And so just before I start throwing out acronyms that no one understands, IDEA refers to the Individuals with Disabilities Education Act, which is the federal law that requires public schools, i.e. any schools receiving federal funds, to provide a free, appropriate public education, or FAPE, to eligible students with disabilities. As of the 2018 to 2019 school year, IDEA was applying to and responsible for providing services and early intervention services to over 7.5 million students within the United States. So this is not something that's not prevalent everywhere and that doesn't have a lot of kids receiving services under it. You'll hear me talk about two different parts of IDEA, which is Part C and Part B. Part C applies to those children from birth to 36 months and their families, which is important, and we'll discuss that a little more in a second. And then Part B applies to those children and youth from after they age out of Part C at 36 months until they're 21. And again, it applies to all schools receiving federal funds or public schools. So when we're talking about preschool age children, in South Carolina, we have a program called BabyNet, which is provided through the South Carolina Department of Health and Human Services. And it's under IDEA Part C, which is for those early intervention services for kids from birth to 36 months old. Now, the referral process to BabyNet is relatively simple. They have a form set up on their website, and I've included a link to that here. One of the best things to remember is that you have nothing to lose from applying to or referring a child to BabyNet and everything to gain. The worst thing that could happen is that they do an evaluation and determine that the child isn't eligible for services, which is actually a good thing. If the child doesn't have a condition or significant delays that requires them to receive services, that's often something that parents want to hear. And then anyone can refer a child to BabyNet. It does not have to be the parents. It can be the parents, but it can also be, a community member, Sunday school teacher, a doctor who sees the child and notices some delays. Really, anyone can go onto their website and complete that form and get the process started. And again, earlier is always better when we're talking about these kids who already have some delays. The earlier you get them started in these programs where they're receiving the services they need, the faster they're going to start to develop and pick up and, get kind of more on track with their peers. So who's eligible to receive services under BabyNet? The two main categories are the significant developmental delays or an established risk condition. And when we're talking about significant developmental delays, the criteria here are a delay of 40% in one area or a delay of 25% in two areas or more. The delay of 40% or 25% really comes down to the evaluations and the assessments that the experts do for the child. It's not something that we can look at a child and say they're 50% delayed in this area. It's something that the doctors, experts, and those who are doing the evaluations have the assessment and criteria to determine what level of delay a child is experiencing. And then the second category, the established risk condition, is those children who have a physical or mental condition that has a high probability of resulting in developmental delay. So technically, a child could not have any developmental delays at the time they start receiving services, especially when we talk about newborns just a couple of weeks old, there's not going to be much of a difference. But if they are diagnosed with this condition that has a high probability of resulting in those delays, then they're still eligible to start receiving services. For the eligibility process, this is going to seem kind of straightforward, but I just want to walk everyone through it. If they meet that established risk condition, they're automatically going to be eligible. They are diagnosed with that condition that meets the state criteria, and they're going to be eligible to start receiving services. If they don't have the established risk condition, then they can still be evaluated under the significant developmental delays portion of the eligibility process. And then if they meet that, they're eligible. If they don't have an established risk condition or don't have a significant enough delay to receive services, then they're not going to be eligible for services under BabyNet. It does not necessarily mean that they won't be eligible for services at the preschool age or at the school age. And then once a child's determined to be eligible, there's an annual review process. Obviously, those kids with the established risk condition are going to continue to be eligible until they age out of the BabyNet program at 36 months. And those with the documented significant delays are going to continue to be eligible so long as they have a delay of at least 15% in one or more areas, which makes sense when we're talking about those children with significant developmental delays. You don't want to keep the criteria for continued eligibility the same, because it means you're not wanting them to make progress to continue to be eligible. So it's raised a little bit, but it's not raised to the point where they have to no longer have any developmental delays. Just the percentage is changed so that they can continue to receive services so long as they're experiencing enough of a delay in at least one area. So once they decide a child's eligible, the child and the family, which again I think is important to remember here, that this part has a lot to do with the family and not just the child receiving services. So once a child is deemed eligible, they're referred out to a service coordinator whose job it is to create and implement this individualized family service plan for both the child and the family. But again, when we're talking about kids from birth to 36 months of age, a lot of this is going to be more geared towards the family because the child is developing inside the home at that point. They're not in school. Their training and education and development is happening within the home, around the family, and the family are the ones who need the training to be able to provide for the specific needs of that child. This could also provide speech, occupational, or physical therapy if it's needed for the child. And again, they're going to do regular reevaluations just to make sure that this IFSP is actually meeting the child's needs. If anything needs to be changed or modified, to make sure that it is. And those where we talk about the IEPs here in a minute, which are the school age stuff and under IDEA Part B, those are generally going to have an annual review or as needed. Under the IDEA Part C, they're going to be more often because the children are younger, they're developing at kind of a higher pace, and so they're going to be about every 6 months and annually, and then as needed. If something changes in the child's life, like the family moves to a new home where their support system and their training and other things needs to be modified to meet that home and that environment, it'll be changed. Or if the child makes a lot of progress in one area and focuses need to be shifted to another, or they're not making the progress that was hoped for, again, changes can be made to make sure that that child's needs are being met. And you've heard me say several times that children will age out of BabyNet at 36 months of age, and that's because IDEA Part C covers those early intervention services for very young children, whereas IDEA Part B covers children from basically 3 to 21. And that requires these local school districts to provide the free, appropriate public education to anyone who's eligible starting at the age of 3. So a child could have an IFSP under BabyNet and just transition into an IEP with the local school district, or they could be referred to the local school district for evaluation. And the main takeaway here is just that a child does not have to be receiving services under BabyNet to then be eligible to receive services from the local school district. So if a child didn't meet eligibility for BabyNet services, they can still be referred to the local school district and evaluation for an IEP, a preschool IEP. So I've already said the acronym several times, but what's an IEP? This is the individualized education plan that's designed to meet the child's specific needs. It's always going to be written, and every child who receives special education services is going to have an IEP. That's required under the law, it's required under IDEA, and so that's why it's going to be put in place. And this is going to be the tangible thing that lays out the programs, the goals, the services for that individual child. And it's going to be what's modified, changed as the child's needs change. So I'm just going to give kind of a brief overview of the procedures for preschool IEPs, and a lot of these will apply the same to school age IEPs. And so we'll go into a lot more detail when we get to that portion of the presentation after Mary Lou talks to us about Social Security. So the initial evaluation would occur. Essentially, a parent or anyone can, like a parent or school or other agency, can request that the child be evaluated. Once that evaluation is done, the evaluation will determine if the child has a disability and what services are needed for that child's disability. And then the IEP team will meet to create the IEP, make sure that it's tailored for that child's specific needs. That IEP team could include the student where appropriate. It's definitely going to include the parents or the people acting as the child's parents in this situation. A school administrator, someone who can kind of make decisions for the school. That's generally going to be a principal or vice principal, a general education teacher, a special education teacher, and any evaluation personnel who did that initial evaluation determining the child's disability and needs. And like we've discussed already, it's going to provide all of the planned services and everything that's going to be given to the child to meet their needs, and also that speech, occupational, or physical therapy if that specific child needs those. Once it's created, the school district's job is to implement it, and they'll start, providing all of the services that are included in it. And then there's going to be a regular review, reevaluation, and modification of it as needed for that child. So I know that was a lot of information very quickly, and I'll discuss the IEP process a lot more in detail when we discuss the school age IEPs. But for now, I'm going to hand it over to Mary Lou to talk to us about Social Security disability and supplemental security income for these children.
Okay, thank you, Lanier. That was very informative. I'm Mary Lou Seymour, and I'm the Regional Benefits Paralegal located in the Greenwood office. And let's see if I can make this thing move to the next slide, which I can't.
There we go.
There it is. Okay. I need to go back 2 slides. Somehow we missed. I am eventually going to talk about Social Security and SSI disability for children. Both of these programs are administered by the Social Security Administration, and I have put information on how to apply for SSI in your chat box because I didn't put it on the slide. The same for both programs is, what is the same? Is the child must be disabled under Social Security regulations. The Social Security Administration covers a vast amount of benefits for different criteria, and for disability, and I can't seem to make this thing move, Lanier.
Okay, let me see if I can fix that. Okay, you want to try it again? Okay, how about now? There we go.
What are the criteria for children's disability? The child's condition must meet or equal the medical criteria in the listing of impairments, or the condition must functionally equal the listing of impairments. Conditions can be physical, like heart, asthma, lungs, etc., or mental, ADHD, depression, or they can be a combination of both. Just because a child is eligible for BabyNet or an IEP does not mean that they meet the criteria for disability for Social Security purposes. If a child's impairment does not meet or equal the listings, the child may establish disability by having a marked impairment in 2 domains or an extreme impairment in 1 domain. Now, what is the difference between marked, moderate, and extreme is fairly subjective. Marked generally means that they have a functional deficit that is 2 steps above normal, below normal, but it can mean other things, and it's very subjective. The 6 domains are acquiring and using information, attending and completing tasks, interacting and relating with others, moving about and manipulating objects, caring for yourself, and health and physical well-being. Whoops. Back to domain 1. This is acquiring and using information. This includes things like how well the child is doing in school or preschool, with learning and using the information learned. If the child is preschool and not attending daycare, the developmental milestones are used. These are the CDC developmental milestones, which we'll talk about some more in a minute, but you can look up what the developmental milestones are for ages 2 months through 5 years on the CDC website. Now, like disability for an adult focuses on whether the person is able to work independently on a steady full-time basis, disability for a child focuses on how well they are doing in school or preschool, whether they're up to grade level, and what extra help, if any, they may need. As with adults, the child's behavior at home and in public is also considered, as it affects their ability to sustain employment or succeed in school. Domain 2 is attending and completing tasks. This domain focuses on how well the child pays attention and completes tasks in school or at home, and how much help the child needs to pay attention and complete the tasks. This domain can include tasks at home, such as doing your assigned chores, taking care of pets, keeping the room clean, and etc. Domain 3 is interacting and relating with others. This domain involves how well the child plays with other children and relates to teachers and family members. Is there any conflict? Does the child initiate activities? Does the child show respect for others, teachers, and children? And it can also include how the child treats animals and pets. And that is often one of the most important things we run into. Domain 4 is moving about and manipulating objects. Can the child move around, walk, climb, crawl independently? Can they tie their shoes, ride a bike, engage in other age-appropriate activities? Is it a physical or mental impairment that prevents the child from these activities, or is it both? Domain 5 is caring for yourself. That's, is the child able to grasp, bathe, feed himself, toilet independently, or does he need assistance or supervision? 6 is health and physical well-being. If the child is often sick and misses school, if they're often hospitalized or have to undergo medical procedures such as a nebulizer and how much time that takes, do they have to go to a lot of doctor's appointments or mental health counseling appointments, and how often? Now, after you've applied for Social Security or SSI disability, Social Security will then proceed to obtain the child's records from the doctors, hospitals, counselors, and schools. I note here that they rarely obtain records from daycare centers, so that's always a good thing to get, is records from daycare centers, particularly if the child is having problems at the daycare center. And it's up to you when you apply to tell Social Security about every doctor, counselor, etc., that your child has been seen by. The most important school records are the IEP that Lanier has talked about, and discipline records, as well as grades. The IEP often includes a psychological evaluation. For preschool children, records from the daycare and the pediatrician's evaluation of the developmental milestones are important. And this is where you can view the CDC developmental milestones for the age of your child, and I've given you the website. Pediatricians normally will do the developmental milestones on your child usually every time you go in there, but every 2, 4, 6 months, 1 year, etc. And you can ask the physician to see the developmental milestones for your child. For children under school age 3 to 6, an IEP can be obtained through the public school system, as Lanier has mentioned. The IFSP, which is BabyNet, is good evidence for the child 0 to 3, as is the IEP for the child from 3 to 6. Social Security rarely obtains functional evaluation from doctors or counselors, and you can help your child's case by obtaining these functional evaluations. Okay, let's say you have applied for disability or SSI. And I missed the slide on what is the difference in disability and SSI. Social Security disability is if the child has a parent that is on retirement or disability, the child can draw off of them. There's no income or assets limits. SSI, there is an income or asset limit. You get a monthly benefit with both programs. Now, if your child claim is denied, you have the right to appeal, and it's always within 60 days. SSDI claim can be denied if you're applying on the earnings record of a retired, disabled, or deceased parent, and you have problems establishing paternity. An SSI claim can be denied because the parent's income or assets are above the guidelines, and both claims can be denied if the child is not found to be disabled. Claims for disability are often denied at the initial level and the reconsideration level. If they're denied, you can request a hearing before the administrative law judge. And you have the right to representation by a lawyer or other advocate, and legal services can provide assistance in developing your case and representing your child. Now, these are questions that I always get. How do I know if my child is disabled? And the best thing to do is to put in an application and provide all the information to Social Security. If it's then denied, then you may wish to contact an attorney or advocate to investigate the claim and help you develop your case. because it's impossible to tell exactly why the child is denied until we've looked at all the records and the medical evidence and seen what else is needed to prove that they have a disability. And how do I know if my child is income qualified for SSI? Families of children must meet the income and resource limits for SSI, but Social Security doesn't count some of the parents' income. In other words, some of it is deemed available to other children in the home or to the parent. Same with assets. The best thing to do is to provide all the information to Social Security, and if it's denied, to contact an attorney or an advocate. And Legal Services does do these cases. We've done them for many years. One of the things I have noticed, particularly in children's cases, is a child has gotten on SSI with something like low birth weight. And at about age 3, the child no longer has low birth weight, so Social Security will say that disability has ended. But the child may often have many other problems that have developed, and that's why we always would suggest to appeal that cessation and see what other impairments the child might have picked up along the way. And that's it. If you have any other questions, we will be answering questions at the end.
Alrighty. Thank you, Mary Lou. So now let's talk a little bit more about education and accommodations, but this time for school-age children, which would be 5 to 18. So just to recap, the IEP is the Individualized Education Plan that's created under IDEA. And IDEA is that federal law requiring schools to provide a free and appropriate public education to students with disabilities. Now, the other thing I wanted to make sure to mention here is the 2 points that I've underlined, which is that this education should be of benefit to the child and should prepare the child for further education or to live and work independently. These two kind of buzzword phrases become important when we're talking to schools and negotiating for services, because those are what the school is required to do. They have to make sure that this education benefits the child and prepares them for further education or to live and work independently. So when you're negotiating with a school for services or things along those lines, these are 2 of the points that you should come back to, and we'll discuss that a little bit more later. Secondly, IDEA requires that education occur in the least restrictive environment, meaning if a child could learn in a general education classroom with accommodations or some modifications, then they should do so. The school isn't allowed to place a child into a special education or self-contained classroom or even put them on homebound services just because it's easier for the school district to provide them services in that environment. If a child can learn in a less restrictive environment, then that's where their education needs to occur. And finally, IDEA provides this other protection for kids with disabilities in that their disability is taken into account when the school is enforcing discipline. So when we talk about the IEP meetings here in a minute and we talk about parents, I also wanted to point out that parent can mean a few different things when we're talking about IEPs and under IDEA. So obviously it can mean a biological or adoptive parent or a legal parent of the child, but it could also be a foster parent who has the authority to make educational decisions at that time. It could be a guardian who's authorized to make educational decisions, or it could even be an individual acting in the place of a biological or adopted parent with whom the child lives, or someone who's legally responsible for the child's welfare. So we see situations where the parents aren't involved. They may have their own life issues that kind of take them away from their child, and the child's being raised by a grandparent or an aunt or an uncle someone else that the child's living with. And so IDEA does allow those people to be involved in the process and to help make decisions for the child. And then finally, if none of these other ones are available, the school or a surrogate parent can actually be appointed in accordance with certain provisions of IDEA. So to start off, just the general rights of parents in this process is they have the right to see any and all records. This seems somewhat self-evident, and that parents always have the rights to see their kids' school records, but it's important to point out here that it includes not just those normal attendance and report cards and things like that, but also any evaluations, any write-ups for disciplinary problems, anything that's going to be used in this process to consider by the school district or the IEP team. The parents have the right to all of that information. They also have the right to participate in meetings about all of these things I've listed here. I won't specifically read them off to you, but it basically means the parents have the right to participate in the IEP meetings. The IEP team can't make decisions and do things and go forward without the parents' participation, unless the parent abdicates their participation, and then the school is kind of required to continue to go forward with these things under the law. And then parents also have the right to prior written notice whenever the school wants to make any changes to the IEP, or the identification of the child's disability, the evaluation, the placement of the child, as in the setting where the child's receiving education, or anything else impacting the provision of a free and appropriate public education to the child. Essentially meaning you can't go to an IEP meeting and put certain services and plans in place and then have the school district call you a month later and say, oh, well, for the past 2 weeks, we've been doing this different. They have to give you prior written notice whenever they want to make a change, and failure to do so could be a due process violation. So the parent's consent is going to be required throughout every step of this process, but primarily we're going to talk about it right now in the form of the initial evaluation. So written informed consent is required from the parent for an initial evaluation for an IEP under IDEA. And essentially this could be a letter sent to the school district or a school administrator saying, my child's been having certain issues. I think they may need services, and I would like for them to be evaluated. Technically, the parents don't have to request the initial evaluation in a written manner, but they would then have to give written informed consent before the evaluation can happen. But we always tell parents, go ahead and make that first request in writing, and that way you have a record of when the 60 days for the evaluation should start. Obviously, there are some exceptions to this. For example, if the child's a ward of the state and DSS can't find the parents despite reasonable efforts, or the parents' rights have been terminated and they're no longer the decision maker for that child, or if you have another court order like a custody order or a guardianship order that gives someone else the ability to make these decisions for the child. So how does this whole process start when we're talking about, the evaluation, the IEP meeting, and those things, and actually implementing and getting to the point where you have an IEP? So the first thing is going to be a request for an evaluation. This can come from the parent or a state agency who has custody of the child, but it can also come from the school. Under IDEA, schools are required under this child find portion of IDEA to identify students who may have disabilities and who may need services. And so the initial evaluation may start at the request of the school, but the parents are still going to have to give that written informed consent to do the evaluation. Once that's given, the school has 60 days to evaluate the student. Now, This 60 days can change depending on some things because there are specific definitions and idea of how that timeline is calculated. But one of the big ones that we run into is sometimes at the end of a school year, parents will request an evaluation and think that the school has to do it within 60 days. If it's requested within 30 days of the end of the school year, then the school just has to complete the evaluation at least 30 days prior to the next school year. The evaluation is going to cover more than just academics. It also has to cover developmental and functional information, which is why it's oftentimes called a psychoeducational evaluation, just because it includes both the educational assessment, but also the other developmental and functional evaluation. And finally, the evaluation is going to determine if the child has a disability and what that child's educational needs are due to that disability. So these are some examples of just disabilities that would qualify for services. The intellectual disability, blindness, deafness, other health impairment, or specific learning disabilities. These are those that wouldn't ordinarily be thought of right off the bat as something that would qualify a child for services under IDEA. But if that other health impairment or some other thing, or the multiple disabilities impacts that child's ability to learn and that child's ability to receive a free and appropriate public education, then they can still qualify for services, even if they don't have like a specific diagnosis or something that can be pointed to. Once the initial evaluation is done, the parents do have some options. If they disagree with that evaluation, the school district's required to pay for an independent education evaluation. Now, the initial one is normally performed by a district psychologist or someone else with the expertise to do these. And that independent one would be a neutral third party and expert, but would be paid for by the school. And once the evaluation is done, the IEP team meets to go over it and decide whether the student qualifies for services. And if they do, then the parent has to give consent for those services to be provided. So there's kind of two meetings that happen. The initial evaluation meeting where a determination is made, and then if it's determined that the child is eligible, then they'll arrange to have an IEP meeting where they'll actually create the IEP for that specific child. And again, just to reiterate, the IEP team is going to be the parents, at least one regular education teacher, at least one special ed teacher, a representative from the local agency, which would be that administrator, principal, vice principal person, other individuals who have knowledge or expertise about the child. So with a lot of these children, they're seeing certain doctors, certain specialists, therapists, psychiatrists, any of those people who could have input in this process and know specifically what that child needs can be included on the IEP team. And then again, when appropriate, the child can be included on the team. So these IEP meetings are generally where a lot of the issues in these cases arise. And some of it comes from that parent expectation and participation. Sometimes the parents go in expecting that the school is going to give them everything they want for their child. And the fact is the school is going to give them what they're required to give them, meaning those services that they believe the child needs, and the parent may have a different opinion on what their child needs. So the parent needs to go in there prepared to work with the team, but also negotiate for the services they believe their child needs. Ask questions. Don't be afraid to ask questions. I can almost guarantee you, you're not going to know every service or option available when you walk in that room. And also don't assume that if you want something and the school doesn't say it's available, that it's not an option. If it's something that the child truly needs, then the school is required to provide it if it's necessary for that child to receive a free and appropriate public education. You can always ask for accommodations or modifications to assist in that. And then finally, just remember, this is a team. A lot of times parents go into it thinking, it's me versus the school district. They're going to fight me on everything that I need or everything that I want, and I'm going to fight them for everything that I want. The idea of the team is that everyone's invested in meeting the needs of the child. So at times it may seem like the school district doesn't want to meet your child's needs just because they're not giving you everything that you want. And so just keep in mind that this is a team effort, and on the outset, don't go in there thinking that you're working against them. Now, with that being said, there may come a time where you are working against the school district, or you disagree about something that's in the IEP or something that needs to be added to it. And when that happens, just keep in mind this little quote here of, explain, don't complain. Now, it's not saying that you may not have valid complaints, but when you start off, think logically about why you're requesting what your child needs and make reasonable arguments for why that's necessary, why that's going to meet your child's needs, and why it needs to be addressed right now as opposed to later. Sometimes schools may say, oh, that's a good idea, but let's try this first. And if you think that it's something that's necessary right at this minute, you need to be able to explain that and explain why. And if that happens, you're more likely to get a better response from the school district as opposed to them going automatically in defensive mode, which is that second part of the quote. The surest way to start a fight is to begin with an accusation. Sometimes, parents walk into these meetings, they ask for all of their wants. The school district says that they're not going to give them all of their wants, and the parent immediately reverts to, you don't care about my child, you don't want to give my child what they need. And a lot of times that's not the case. It's this, that the school district disagrees with you on what the child needs. And so in order to avoid kind of putting them into automatically having to defend their position, just, explain your position, give them an opportunity to explain theirs, and then if you guys don't agree at that point, then you can pursue some of the other options. So if you disagree with the school on what the child needs or what should be in the IEP, you do have options to kind of appeal that decision. The due process hearing is the one that people always think about. It essentially says, my child needs these services and the school is refusing them. Therefore, my child's been denied due process under IDEA. Always seek legal advice before you request this, because if the complaint isn't resolved before the hearing, there's going to be a hearing. The school district will select and pay the hearing officer, and then whoever wins could force the other side to pay attorney's fees. Generally, if the parent has an attorney, the school district will have theirs there, and also vice versa, in that if the parent does not appear with an attorney, the school district won't. Now, that's not to discourage the parent from bringing an attorney, and that they don't want to bring an attorney and then lose and then have to pay for the school district's attorney, because oftentimes that whole attorney's fees thing can be worked out, or every side can agree to pay their own or anything along those lines. That's just a possibility that we want to make people aware of. Mediation is another option, and this is often done kind of before we get to the final point of having a due process hearing. That's where the State Department of Education will supply a mediator. The mediator will sit down with the representatives of the school district and the rest of the IEP team and the parent, and try and just work out, if any solutions can be reached between everyone before having to go to a due process hearing. And kind of the final option that can occur alongside a due process hearing, or at the same time, or after or before, would be filing a complaint with the State Department of Education, explaining the situation and why you believe that the school has violated some portion of IDEA or state law, at which point the Department of Education will investigate, and if they find there's violations, they issue what's called a resolution, laying out what the school district is going to do to fix that problem. And there's no cost to file that complaint with the State Department of Education. So finally, and I'm going to move through this relatively quickly because I want to make sure we have a little bit of time for any questions we may have. Children could also receive 504 accommodations under Section 504 of the Rehabilitation Act of 1973. So we often talk about this in terms of if IDEA doesn't apply, what type of accommodations could a student get? But a student receiving an IEP could also receive 504 accommodations at the same time. This Section 504 protects students with a disability who have a physical or mental impairment that substantially limits one or more major life activities, have a record of such an impairment, or are regarded as having such an impairment. So you'll notice here that the disability category is a lot broader under 504 than it is under IDEA. And again, as I mentioned, these things can happen separately. They don't have to happen before or after the other. They can happen at the same time or whenever it's needed. This section is going to apply to a lot more students because the eligibility or the definition of disability is broader. IDEA is always going to have all those strict evaluation and procedural requirements that 504 doesn't necessarily have. And this can actually extend into non-educational programs such as extracurriculars or after-school programs because it requires the schools to provide those accommodations in any setting, not necessarily just in the classroom. So as I mentioned, a lot broader here. It's not as formal and not as procedurally heavy when we talk about 504 plans, which means the evaluation isn't going to be as detailed, and the meeting, will be the parent 504 coordinator and other individuals to determine whether a child qualifies and then implement or create a written 504 plan, which would be a lot shorter than an IEP. However, a child could be receiving 504 accommodations but not have a written plan. So for instance, if a child gets extended time on test, but there's no written document anywhere saying that they're getting it for an impairment, that's still a 504 accommodation. It's just not, formally written, it's just being implemented. And again, just like the IEP, there will be regular reviews to make sure that those accommodations are meeting the student's needs. And the last thing I want to mention about 504 plans is that they can continue after high school or after the student leaves school. Colleges are required to implement 504 plans. So if the kid goes on to college or university, the school is not necessarily going to know about the 504 plan beforehand. So the student or the parent will need to contact the school, provide them with all the information they need, and generally that's going to be through what's called a disability services office. IEPs, on the other hand, don't continue into college, but a lot of the accommodations and other things in place under an IEP could be rolled into a 504 plan in college. You just need to request it at that time. And then finally, you can also request reasonable accommodations in employment. Just keep in mind that the child or student needs to be able to perform the essential functions of the job with or without those accommodations. So with that, any questions from anyone? Susie, do we have any in the chat?
Hey, Lanier, great presentation. There are a few questions. A number of them do have to do with the subject matter that you said would be in part 2 of this series, which is essentially when children turn 18 and some of the issues surrounding guardianship, powers of attorney, child custody, housing, and that sort of thing. So I would just, that's another presentation entirely. So I know it's hard for y'all to address those in the short amount of time that we have left, but I encourage our listeners to, if you have some of these issues, the next part of this series will be on May 4th, Tuesday, May 4th at noon. And we'll have a more in-depth discussion of some of those factors that you may be looking at. In the meantime, however, I do suggest that if you have those issues and you need a lawyer's help or advice with that, you certainly can apply for our services, and we'll show that information in the next slide. A couple of things that you may have time to answer, folks, is the question, is ADHD considered special needs? I don't think that was on that list.
Okay. I'll give the lawyerly answer of it depends. A child could have ADHD and function well enough to where it's not considered a disability in terms of IDEA, as in it doesn't impact their ability to receive a free and appropriate public education, but they may need certain accommodations, like under a 504 plan, extended test time, testing in, like an isolated classroom away from distractions or things like that. So not necessarily just based on the diagnosis. However, it definitely can be if it impacts that child's ability to receive a free and appropriate public education to the extent that they need additional services or an additional, an individualized plan in place for them. So a lot of that just comes down to the evaluation and what's determined from that. And then again, if the school district evaluation doesn't give you the answer that you think you should have as to whether or not the child has a disability, you can always request that independent one paid for by the school district, and maybe you get a different answer from them.
And let me add that for Social Security and SSI disability, ADHD is definitely considered. What Social Security always looks at is not so much the diagnosis as what the effect is on the child's functional abilities. And that's the same thing as in the school system, is what they're looking at is not simply the diagnosis, but how it affects the child's abilities to function.
Okay, that's great information. And then one other thing you may or may not be able to address or have any thoughts on is, a lot of schools provide these Chromebooks to their students and allow them to take them home and all. Any particular suggestions on those who may have no Wi-Fi at home or may just have poor internet access even when they do have it? Is there any particular way to address that? Do you have any thoughts on the rights and responsibilities when it comes to the Wi-Fi access?
Yeah, so this is another one that's become obviously a huge issue over the last year. And just before that, when schools started implementing these technology programs before, lockdown and quarantine and at-home schooling, the main takeaway, I guess, is that the school district doesn't have any responsibility to provide Wi-Fi or broadband or any internet access directly to your home. There's not going to be anything finding that the school has a responsibility to pay your internet bill to make sure you have good Wi-Fi at your house, but they do have to provide the ability for a child to access what they need to receive the free and appropriate public education. So what we've seen a lot over the last year is these schools implementing their hotspots. Sometimes it's at the actual school and they just kind of put extenders and Wi-Fi extenders to get it out to the parking lot where students can show up in their cars and learn from there. Public libraries or things like that. A lot of it is just the school has to provide the access so that the child has the ability to receive a free and appropriate public education. And when we talk about students with disabilities under the IEPs, they may get more specific in providing that specifically for that child. But the main takeaway is that, yes, they have to provide the access and make it available, but they're not going to necessarily have to provide it like in your personal home.
Okay, very good. Now here's a somewhat related question, very interesting to think about. I don't know if we have any answers on it yet, but what about a child who was kept out of preschool because of COVID-19 and they may be, you know, sort of delayed as a result of not being able to attend preschool?
That is a good question.
I thought so too.
I think a lot of it, will come down to the evaluation. So that's always the first step. Request an evaluation, have, them do what they need to do assessment wise and evaluation wise. And if at the end of the day they determine that the child has some type of disability, whether it be like an other health impairment or, a specific learning disability or something else that qualifies them for services because they didn't get what they needed because they weren't able to attend preschool. But if it's something that's just like if the child doesn't have anything specific to themselves and it's just a matter of they missed preschool because of COVID, I'm not sure what the school's responsibility would be, especially when we're talking about situations where lots of students may have missed preschool and what the school's obligation is to those students as a whole. I'm not really sure. Obviously, they can request an evaluation, and if the evaluation determines that there is, then yes, they're going to be eligible. But as far as just based on the fact that they missed preschool due to COVID, I have no idea. Maybe we'll get some guidance from either the state or federal or local governments on that, but I don't have anything at this time.
Well, I think you make a good point that that is an across-the-board issue for a lot of folks. But when there is a special needs child involved, that certainly can be a different animal when you're looking at these issues. So good answer. We'll see what happens. That is really all the time we have for today. So let me first thank you, Lanier Sims and Mary Lou Seymour, for an excellent presentation on a subject that's so important to so many of us. And hopefully we have some good understanding and know more about now. And I want to thank all of you who joined us today. We certainly do appreciate your interest in the subject matter and the other information that we present on Tuesdays at noon. Remember, Level Up Law is a free webinar every Tuesday at noon where we educate the public on some of the common legal issues that we see here at South Carolina Legal Services. Now, all of these webcasts can be found on our YouTube channel, so just go to that Level Up Law playlist on our YouTube channel at SC Legal. And we'll mention that if you are interested in getting a copy of the slides, we will post them on our lawhelp.org/SC legal resource website, and we will link to that when the recording of today's webinar is posted on our YouTube channel. Okay, if you found the presentation today by Lanier and Mary Lou helpful, which I'm sure you did, please be sure to go to that YouTube channel and give it a thumbs up, and also share it with others that you think it may be of interest and importance to. And while you're there, if you go ahead and subscribe to our YouTube channel, you can sign up for alerts and you'll get a notification every time we post a new episode, whether you were able to join us live or not. Now, make a note that the second episode in today's series is scheduled for May 4th. So those of you who had some of those more detailed questions about 18 and older, you're going to definitely want to tune in for that. But if you do have an issue in the meantime and you need legal assistance and you can't afford a lawyer, you can see on your screen right now the information about how to get in touch with us here at South Carolina Legal Services, because you may be eligible for our free legal representation, and we do want you to apply. The great staff at our intake office is standing by, but also you can also apply online at lawhelp.org/SC. And we actually have a Level Up Law episode on our YouTube channel that walks you through some tips on how to make that online application go smoothly for you. Now remember, an easy way to see what's coming up each week is to check our Legal Services Facebook page, South Carolina Legal Services Facebook page, but also follow us on Twitter and Instagram and even LinkedIn, and we have that information there as well. Now, next week's episode, I know everyone wants to hear about that. What's coming up? Next week, we'll be talking about Medicaid, Medicare, and the Affordable Care Act, how they are different in South Carolina. So please be sure to join us for that. So thanks again to everyone for tuning in to Level Up Law today. Thanks to Lanier and Mary Lou. We look forward to having everyone back with us next week. So take care, everyone. That concludes today's webinar.
Thank you.